0. We were waiting on audit. Where are we?
Judge, I'm happy to announce, thank you for the court being so lenient with us and resending this a few times. Mr. Wimberly is actually here this morning with his client, my complainant. They did send me some documentation just right before docket. He's also indicated that his office is this week making notebooks for Mr. Kelly and myself and having everything scanned in. If we may just have one final, now that we have all that information, hopefully I can sit down with them, then Mr. Kelly and I can sit down and discuss it and see where we are and be ready to finally announce next time that I did on we have all that documentation.
Okay.
It should be to me this week.
All right. Thank you, Mr. Wimberly.
Right.
All right. So what I'm going to do,
And if you want to go ahead and put it on the trial docket, Judge.
no.
I certainly would understand.
Yeah, no, I just want to see.
My only concern when I hear notebook is
That's what I'm thinking as well.
talking about.
Yes, sir.
It'll be about that thick.
Okay.
With all the head.
So why don't we do this? When we come back next time, I want it all done and I want an answer. And so what I'm going to do is reset it to the 1st of January. That should be about a 60-day, a little more than that. I want everything hopefully turned over this week. That gives you an opportunity. So unless there's something else that comes up, I want it all gone through in an announcement at the next court date.
Yes, ma'am.
Okay? All right, you're free to go. Thank you, sir.
Thank you.
Thank you, Mr. Kelly. Ma'am, you're Brianna Clanan. And will your client waive the formal reading of the indictment?
She will.
Ms. Clanan, in cause number 25, DCCR 0446, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from March 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine.
I'll explain my scribbles, Your Honor.
That's CCCR. There would be a dismissal in cause number 25 CCCR 1119. And this will run concurrently with 25 CCCR 1053. Is that your understanding?
There should be another misdemeanor. It was refused. I was refused.
And what are those
The
cases?
dismissed one is resisting arrest, and they're all connected to this, Your Honor. The dismissal is resisting arrest. The case to be pled is a DWI.
Okay.
All out of the same criminal episode.
Let me look at something real quick. Okay, so I can't see that. If I test you this morning, will you be clean?
Be honest.
Have a seat in the jury box. Good morning. Are you Ryan Hodge?
Yes, ma'am.
And Mr. Hodge is charged in cause number 24, DCCR 1167. With the third-degree felony offense of evading arrest or detention with the use of a vehicle. The indictment alleges a prior burglary from 2015, and then also felony of bribing an officer in 2018 and possession of a firearm by a felon in 2018. We had reset that as well. Some other stuff as well.
Those are out of state.
Yep. So what that means, though, is for punishment purposes, if Mr. Hodge, if you're found guilty by a jury, you would be considered a habitual offender, which means your minimum punishment, if you go to trial and are found guilty, is 25 years in prison, up to 99 years or life in prison. Do you understand? And we reset this case for you guys to watch the video. And have you had an opportunity to review the video in this case?
I've seen the prior, vision.
You see the video?
I think
Yeah,
he's seen it with his prior.
Okay.
Previous.
So you've seen the video, and have you talked to Mr. Kimler about it? Answer out loud.
Do what, ma'am?
You
Have
say
you
we
s-
talked about this.
We've talked about it, yes, ma'am.
Okay. And I want to make sure. So I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count one only, which is just the offense of evading arrest or detention, not those prior offenses, for a cap of 10 years, which means you would leave your punishment up to me. I can give you 10 years. I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And so I'm also making the notation here on that plea bargain rejection that I've admonished you as to what the minimum will be if you're found guilty, which is 25 years in prison. You understand? And you want to reject that and have your case set for trial.
Yes, ma'am. I didn't want it. I was just being driving.
Just maintain this.
All right. Then I do want to make sure you understand that after today, I will not accept a plea agreement. I'll get your case set on the trial docket. There won't be a plea. We'll let a jury decide. Okay?
So, for any reason, we can't look into it further. Like the facts and the evidence.
Well, that's what a jury's for. And so your attorney has discussed the case with the assistant district attorney. Their position is that it's an evading and they think they can prove that. And that's what we're going to go to trial. Okay? That's what a jury's for. All right. Okay. And she'll waive the formal reading of the indictment in each.
Yes, sir.
So, Ms. Randall, in clause number 25, DCCR 0246, you're charged with a state jail felony offense of theft of property with previous convictions. And that one's from November 21st of 2024. The indictment alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985, both misdemeanors, which would get us to this state jail felony level. It further alleges that you were convicted of a non-state jail felony offense of theft April 10th of 1989, and then again November 12th of 1991, and then after that was final, October 10th of 1994. And how do you plead to that charge? And are those prior offenses true? Or prior convictions true, excuse me. Are you entering your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? All right, give me just a second to get this pulled up so I can make that notation. And I think that was 1 through 5.
This courtroom hearing may seem routine at first, but within minutes the stakes become enormous as Judge Raquel West begins handling felony cases involving probation, evading arrest, theft charges, and plea negotiations that could completely change multiple lives. One defendant is already preparing to plead guilty, while another is about to reject a plea offer that could mean the difference between a possible sentence reduction and spending decades in prison. And the tension inside this courtroom rises fast when the judge starts laying out the real consequences tied to these decisions. What makes this hearing so intense is not screaming or chaos. It's the reality of what's being said. Every defendant standing before this court is being forced to make choices that may affect the rest of their lives. And once those choices are made, there may be no turning back. This is the exact moment where the pressure inside the courtroom completely shifts. Legally, Judge West is making something crystal clear to the defendant. Rejecting a plea deal means risking a jury trial where habitual offender enhancements could dramatically increase prison exposure. In this case, the defendant has already been warned that a guilty verdict at trial could carry a minimum of 25 years behind bars. Emotionally, you can hear the hesitation and uncertainty as the defendant tries to understand the seriousness of what's happening. But once the court places those warnings on the record, the risks become very real. Here's the question. If you were facing decades in prison, would you gamble on trial or take the deal already being offered? That tension now hangs over the courtroom as Judge West prepares to move this.